Imagine walking out of your house in the morning, getting into your car, and driving to work. You stop for coffee. You run an errand at lunch. You swing by the grocery store on the way home. Now imagine that during that entire time, from the moment you left your driveway until the moment you returned, your vehicle was photographed, logged, analyzed by artificial intelligence, and stored in a searchable government database. Not just once, not just at a toll booth, but potentially dozens of times in a single day. That's the concern at the center of a new federal class action lawsuit filed against the city of San Jose, California, over its use of hundreds of automated license plate reader cameras, often called ALPRs. The lawsuit was filed by 3 San Jose residents working together with the Institute for Justice, a public interest law firm known for litigating constitutional cases. They argue that San Jose's massive network of license plate reader cameras violates the Fourth Amendment to the United States Constitution, the amendment that protects against unreasonable searches and seizures, and the numbers involved here are not small. San Jose currently operates 474 automated license plate reader cameras throughout the city. When the system was first introduced in 2021, it began as what many would call a limited pilot program, just 4 cameras placed at a single intersection. 4 cameras. That was the entry point. But since then, the program has expanded dramatically, from 4 cameras to nearly 500. That's not a minor increase. That's citywide infrastructure. According to attorneys involved in the case, San Jose's ALPR system is one of the largest municipal systems of its kind anywhere in the country. And it's not just the number of cameras that concerns critics. It's also who has access to the data and how it's being used. The lawsuit alleges that thousands of government employees across California have access to the data collected by San Jose's system. That means individuals outside of San Jose, potentially in other jurisdictions, can query the database, and they can do so without obtaining a warrant. According to the complaint, searches of San Jose drivers' data occur thousands of times per day. Thousands. And the plaintiffs argue there is little meaningful oversight of how those searches are conducted. To understand why this raises constitutional concerns, it helps to understand exactly how ALPR systems work. These are not simple traffic cameras. They do much more than snap a picture of a license plate. Automated license plate reader cameras photograph every vehicle that passes within range. The system uses artificial intelligence to convert the images into machine-readable data. That includes the full license plate number, partial plate numbers, time and date stamps, and GPS location information. But it doesn't stop there. Modern systems can also identify the make, model, and color of a vehicle. They can detect distinctive features, bumper stickers, roof racks, toolboxes mounted in the bed of a truck, aftermarket modifications, and even visible dents or rust patterns. In other words, they don't just capture a plate number. They capture a digital fingerprint of the vehicle. All of this information is uploaded into a searchable database. Law enforcement officers can then run queries. They can enter a full license plate number. They can enter a partial plate. They can filter by vehicle type or color. Some systems even allow officers to upload a photograph of a vehicle and let artificial intelligence search for similar matches. They can type in descriptive terms and generate results based on those characteristics. If someone wanted to find every red pickup truck with a ladder rack that drove through a certain area last Tuesday, that search could potentially be performed. And because many jurisdictions share their data with other law enforcement agencies, sometimes even opting into nationwide databases, the scope of these searches can extend far beyond city limits. That means a query could, in theory, request information about every vehicle matching certain characteristics across multiple jurisdictions. Now, supporters of ALPR systems argue that these tools are incredibly effective for solving crimes. For example, if a witness to a robbery provides a partial plate number and a vehicle description, officers can quickly search the system and determine where that vehicle traveled. That can lead to faster arrests and safer communities. There is no dispute that the technology can help solve crimes. The question raised by this lawsuit is whether the scale and scope of San Jose's system and the warrantless access to its database crosses a constitutional line. The three residents who filed the lawsuit come from different backgrounds, but they share similar concerns about mass surveillance. One of the plaintiffs is a privacy engineer working in the technology sector. He has lived in places including China, Japan, and Massachusetts before settling in Silicon Valley. His experience in China, a country known for its extensive government surveillance systems, deeply influenced his views. He has expressed concern that widespread deployment of license plate readers could enable monitoring of First Amendment-protected activities, such as attending political protests, participating in demonstrations, or even observing law enforcement conduct. As someone who works professionally in privacy engineering, he understands how powerful location data can be. He has stated that even a small number of location data points can reveal deeply personal information about someone's life, where they worship, where they seek medical care, who they associate with, and what causes they support. Having seen what a true surveillance state looks like, he worries that similar systems could gradually take root in American cities without sufficient safeguards. Another plaintiff is a California native who works in the auto parts industry. His father served for many years as a sheriff's deputy in Riverside County. He is not anti-law enforcement. In fact, he says he values the work officers do. But he finds the idea of citywide tracking of ordinary people's movements to be overbearing and, in his words, creepy. The third plaintiff grew up in San Jose and drives past these cameras daily during his commute. Like the others, he finds the widespread monitoring of vehicles unsettling. Their lawsuit contends that collecting and storing detailed movement data about virtually every driver in the city constitutes an unreasonable search under the Fourth Amendment. One aspect of the system that particularly troubles critics is the ability to search by bumper sticker. That might sound trivial at first, but think about it. Bumper stickers are often expressions of political opinion, religious belief, or social affiliation. They are a form of speech protected by the First Amendment. If a system allows someone to search for every vehicle displaying a specific political slogan, that creates the potential for government officials to compile lists of individuals based on their viewpoints. Imagine someone runs a query for every car displaying a particular campaign sticker. The system produces a list. Now there exists a record of individuals who publicly express support for that candidate. Why does that list exist? Who requested it? For what purpose? Will that happen? No one can say for certain, but the plaintiffs argue that constitutional safeguards are meant to prevent the possibility of abuse, not merely to respond after abuse occurs. There have already been reports in other jurisdictions of misuse of ALPR systems. In some areas, officers have allegedly used the system to conduct searches on behalf of federal immigration authorities. In other cases, officers have reportedly used license plate reader data to surveil protesters. There have even been allegations of officers using the technology to track former romantic partners. In one widely reported incident, a police officer was accused of using plate reader data to stalk his ex-girlfriend by querying her license plate to determine her whereabouts. These examples illustrate why oversight matters. San Jose initially retained ALPR data for 365 days, a full year. That retention period has since been reduced to 30 days. While that change limits how long data is stored, critics note that 30 days still represents a significant window of time during which detailed travel histories are accessible. And the question remains, how exactly is data deletion handled? Is it automatically purged? Is it backed up elsewhere? What auditing mechanisms are in place to ensure compliance? The lawsuit against San Jose is reportedly the first to challenge the federal constitutionality of that city's ALPR system specifically. The Institute for Justice has made combating what it views as abusive ALPR practices part of a broader initiative sometimes referred to as a plate privacy project. In October 2024, the organization filed a similar federal lawsuit against Norfolk, Virginia, over its use of more than 170 plate readers. That case became notable for surviving a motion to dismiss meaning the court allowed the constitutional challenge to proceed. Beyond litigation, the organization has worked with activists and lawmakers across the country to push for reforms requiring warrants or limiting data retention. Meanwhile, several local governments have begun re-evaluating their use of license plate readers. In recent months, municipalities including Santa Clara County, Los Altos Hills, and Mountain View have canceled ALPR contracts amid concerns about potential abuse. This broader debate reflects a tension that has existed throughout American history, the balance between public safety and individual liberty. There is little doubt that technology has transformed policing. Artificial intelligence, high-resolution cameras, and vast data storage capabilities now make it possible to document and analyze movements at a scale unimaginable just a few decades ago. 20 years ago, storing detailed location data about millions of vehicles would have seemed economically and technologically impractical. Today, massive data centers can hold and process staggering amounts of information at relatively low cost. The mere fact that something is technologically possible does not automatically answer whether it is constitutionally permissible. Critics argue that when surveillance becomes ubiquitous, when nearly every public movement is logged, it changes the nature of privacy itself. Even if each individual observation occurs in public view, the aggregation of thousands of data points can create an intimate portrait of someone's life. Supporters counter that drivers have no reasonable expectation of privacy in their license plates, which are openly displayed on public roads. Courts have wrestled with similar questions before. In recent years, the Supreme Court has recognized that prolonged tracking of individuals through GPS devices or cell phone location data can implicate Fourth Amendment concerns, even if each individual data point was technically observable. Whether that reasoning will extend to citywide ALPR networks remains to be seen. The San Jose case could become an important test of how courts view mass data collection systems operated by local governments. At its core, the lawsuit asks a fundamental question: at what point does targeted crime-fighting technology become general population surveillance? 4 cameras at one intersection might be seen as limited. 474 cameras across a city begin to look more comprehensive. Is there any place in San Jose where someone can drive publicly without being photographed and logged by one of these cameras? That question lies at the heart of the concern. Because once surveillance infrastructure is built, it rarely shrinks. It tends to expand. And expansion often happens gradually. A pilot program, a successful test, a few more cameras, then dozens, then hundreds. Each incremental step can seem reasonable on its own, but taken together, they can create a system far more powerful than initially envisioned. The outcome of this federal class action lawsuit will be closely watched. If the court finds that San Jose's system violates the Fourth Amendment, it could prompt changes not only in California but nationwide. If the court upholds the system, it may embolden other cities to expand similar programs. For now, the case is pending. It represents a clash between rapidly advancing surveillance technology and constitutional principles written in the 18th century, but still deeply relevant today. No one can predict how the court will ultimately rule. But the debate over automated license plate readers and over the broader growth of surveillance infrastructure in American cities is unlikely to disappear anytime soon.